Understanding our rights and responsibilities under the law is not just a matter for courtrooms and legislatures, it is a cornerstone of informed citizenship. The landscape of firearm regulation in the United States is one of the most dynamic and complex areas of American jurisprudence, directly impacting the daily lives of millions of law-abiding citizens. Recent developments in Congress have brought this topic to the forefront of national discourse, prompting questions about the very nature of the relationship between the individual, the states, and the Constitution. It is essential for every citizen, regardless of their personal views on firearms, to understand these proposed changes as they touch upon fundamental principles of federalism, constitutional rights, and public policy. So, as we delve into the details of the National Constitutional Carry Act, here is a question for you to consider. In a nation with 50 distinct state legal systems, where should the line be drawn between a uniform national standard for constitutional rights and the power of individual states to address local concerns? Please share your thoughts on this question in the comments section below. To properly understand the significance of the National Constitutional Carry Act, formally introduced in the 118th Congress as H.R. 9534, we must first establish a clear picture of the current legal landscape. The United States operates under a system of dual sovereignty, meaning that both the federal government and state governments have the authority to create and enforce laws. In the context of firearms, this creates a layered and often intricate patchwork of regulations. At the base level, federal law establishes a floor, a set of minimum standards and prohibitions that apply across the entire country. These foundational rules are primarily codified in two major pieces of legislation: the National Firearms Act of 1934 and the Gun Control Act of 1968, as amended over the decades. The Gun Control Act, for instance, outlines categories of individuals who are prohibited from shipping, transporting, receiving, or possessing firearms. These prohibited persons include individuals convicted of a crime, punishable by imprisonment for a term exceeding 1 year, fugitives from justice, unlawful users of controlled substances, individuals adjudicated as mentally defective or committed to mental institutions, individuals subject to certain domestic violence restraining orders, and those convicted of misdemeanor crimes of domestic violence, among others. This federal baseline is designed to keep firearms out of the hands of individuals deemed high risk by a uniform national standard. The mechanics of enforcing these prohibitions at the point of sale rely heavily on the federal firearms licensing system. Any person engaged in the business of manufacturing, importing, or selling firearms must obtain a federal firearms license. These licensed dealers are required to conduct a background check on any prospective buyer who is not themselves a licensee, using the National Instant Criminal Background Check System, a computerized system that queries various federal, state, and local databases to verify that the purchaser is not a prohibited person. It is critical to understand that this federal requirement applies only to purchases from licensed dealers. Transactions between private individuals who are not licensed dealers, often referred to as the secondary market, are not subject to this mandatory federal background check, although some states have enacted their own laws to close this gap. This distinction between federal and state authority is a recurring theme in American gun policy. Beyond the purchase and possession of firearms, the regulation of how one carries a firearm in public has traditionally been the province of state law. This has led to a wide spectrum of approaches across the country. For much of modern American history, states generally fell into one of several categories. There were no-issue jurisdictions, where carrying a concealed firearm was largely prohibited for private citizens. Then there were may-issue states, where local authorities, often a sheriff or police chief, had significant discretion to grant or deny a concealed carry permit based on their assessment of the applicant's proper cause or good moral character. In these jurisdictions, simply being a law-abiding citizen was not necessarily enough. One had to demonstrate a special need for self-defense beyond that of the general public. Over time, a majority of states shifted to a shall-issue framework. In these states, the issuing authority is required by law to grant a permit to any applicant who meets specific, objective statutory criteria, such as being of a minimum age, passing a criminal background check, and often completing a certified firearms training course. The discretion of the issuing authority is removed. If you meet the qualifications, you get the permit. In recent years, a significant number of states have moved beyond the shall-issue model altogether and adopted what is known as constitutional carry, or permitless carry. As of early 2026, this number has grown to 29 states. The core principle of constitutional carry is that the Second Amendment itself serves as sufficient authorization for a law-abiding adult to carry a handgun, either concealed or openly, without the need to obtain a government-issued permit. This concept is not entirely new. Vermont has never required a permit to carry a firearm, a tradition dating back to its state constitution of 1777, a practice long referred to as Vermont carry. The modern movement gained traction starting with Alaska in 2003 and Arizona in 2010, and has since spread across much of the country. It is important to note that even within these 29 states, the laws are not uniform. Variations exist regarding the minimum age, which can be 18 or 21, residency requirements, and specific disqualifiers beyond federal law, such as recent DUI convictions in Tennessee. These states demonstrate a legislative trend towards treating the public carry of firearms as a right that does not require prior administrative approval. The constitutional backdrop for all of these legislative activities has been profoundly shaped by a trilogy of landmark Supreme Court decisions. The first, District of Columbia versus Heller in 2008, was a watershed moment. The court ruled that the Second Amendment protects an individual's right to possess a firearm for traditionally lawful purposes, such as self-defense within the home, unconnected with service in a militia. This decision affirmed that the right is an individual one, not a collective right tied to military service. 2 years later, in McDonald versus City of Chicago, the court addressed the question of whether this right applied only to the federal government and its enclaves, or whether it also limited state and local governments. The court held that the Second Amendment right recognized in Heller is fully applicable to the states through the 14th Amendment, meaning that state and local gun laws are also subject to Second Amendment challenge. This doctrine, known as incorporation, ensures that fundamental rights are protected from government action at all levels. The most recent and arguably most impactful decision for the current debate came in 2022 with New York State Rifle and Pistol Association versus Bruen. In Bruen, the Supreme Court struck down New York's May-issue concealed carry regime, which required applicants to demonstrate proper cause to obtain a license. In its place, the court established a new test for evaluating the constitutionality of gun laws. The government must now demonstrate that a modern firearm regulation is consistent with this nation's historical tradition of firearm regulation. If the text of the Second Amendment covers an individual's conduct, such as carrying a handgun for self-defense in public, the burden shifts to the government to justify its restriction by showing a historical analog from the founding era or the Reconstruction era. This decision effectively forced the remaining May-issue states, like California, Hawaii, Maryland, Massachusetts, and New Jersey, to adopt shall-issue frameworks to comply with the ruling. However, as we see in ongoing litigation, such as the case from Hawaii that the Supreme Court recently agreed to hear, the battle has now moved to what constitutes a permissible, sensitive place where guns can be restricted and whether states can use extensive location-based bans to effectively nullify the right to carry. It is within this complex legal and historical context that the National Constitutional Carry Act was introduced. The bill's findings section explicitly links its purpose to the Supreme Court precedents just discussed, quoting Heller, McDonald, and Bruen to build its constitutional foundation. The bill, introduced by Representative Thomas Massie and several co-sponsors, seeks to amend Title 18 of the United States Code, which deals with crimes and criminal procedure, by rewriting Section 927. The current Section 927 is a relatively simple sense of Congress provision regarding interstate commerce. The proposed amendment would transform it into a powerful, preemptive federal statute. The operative language of the bill is sweeping in its scope. It would forbid any state or political subdivision from imposing a criminal or civil penalty on, or otherwise indirectly dissuading, the carrying of firearms in public by United States citizens who are otherwise eligible to possess firearms under state and federal law. The phrase otherwise indirectly dissuade is particularly broad, and the bill explicitly includes in its definition of deterrence imposing a financial or other barrier to entry. This language directly targets the very concept of a permit system. If enacted, any state law that requires a fee, a training class, or a background check specifically for the act of carrying a firearm in public could be construed as a financial or regulatory barrier that indirectly dissuades the carrying of firearms. The bill states that any such state statute, regulation, or even custom shall have no force or effect, This is a direct preemption of state authority, meaning that federal law would nullify and override any conflicting state laws on this subject. The bill does, however, include some limitations. It defines public broadly as any place held open to the public regardless of ownership. This means it would apply to government buildings like parks and sidewalks, as well as privately owned businesses that are open to the public, such as stores and restaurants. Crucially, for private property, the bill respects the rights of property owners. If the owner of a privately owned location that is held open to the public communicates clearly and conspicuously a prohibition of firearms on the premises, then that location is not considered a public place for the purposes of the right to carry under this act. This preserves the fundamental right of private property owners to control what happens on their land. Additionally, the bill's definition of public does not include places where firearm screening is conducted under state law, such as secure areas of airports or courthouses with metal detectors and security personnel. This carves out an exception for locations that already have active security measures in place. The potential implications of this bill becoming law are profound and would fundamentally alter the relationship between citizens, states, and the right to bear arms. The most immediate effect would be the establishment of a uniform national standard for the public carry of firearms. In all 50 states, the District of Columbia, and U.S. territories, any citizen eligible to possess a firearm would be legally entitled to carry it in public without a permit. This would effectively render the permit systems of states like California, New York, New Jersey, Hawaii, and others moot for the act of carrying. Residents of those states would no longer need to navigate their own state's permitting process to carry a handgun, and visitors from other states would be able to carry under the same rules as residents. As Representative Massey noted in his commentary, this creates an interesting dynamic. A citizen from a constitutional carry state could carry in a state like New York without a permit, while under the proposed framework, a New York resident would also have that same right, something they do not currently possess. This raises significant questions about federalism, the constitutional division of power between the national government and the states. Traditionally, states have been considered the primary regulators of police powers, including the regulation of firearms within their borders. The National Constitutional Carry Act represents a substantial exercise of federal power to mandate a specific interpretation of the Second Amendment upon the states, removing their ability to experiment with different regulatory models. While Congress has broad authority to legislate under the Commerce Clause and to enforce constitutional provisions under Section 5 of the 14th Amendment, such a direct preemption of state police powers would undoubtedly face immediate and intense legal challenges. Opponents would argue that it exceeds Congress's enumerated powers and infringes on state sovereignty, while proponents would argue that it is a necessary measure to enforce a fundamental constitutional right uniformly across the nation. It is also crucial to understand what the National Constitutional Carry Act would not do. It would not change the federal prohibited persons list. Individuals barred from possessing a firearm under federal law would still be barred. It would not change the federal requirements for purchasing a firearm from a licensed dealer. Background checks for purchases would still be required. It would not affect the ability of private property owners to ban firearms on their premises, as the bill explicitly protects their right to post clear and conspicuous signage. It would not affect existing federal gun-free zones, such as federal buildings, military installations, and schools, which are governed by separate federal statutes. Furthermore, it would not necessarily eliminate a state's permit system entirely. States could still choose to offer permits for those who want them, primarily for the purpose of interstate reciprocity, as having a permit from a state with high standards can allow a person to carry in other states that have reciprocity agreements but do not recognize permitless carry. For example, Texas, a constitutional carry state, still maintains its license to carry program for this very reason. For the average citizen, the practical legal guidance surrounding this issue is twofold. First, it is imperative to understand that the law is currently a patchwork. Even if the National Constitutional Carry Act were to pass tomorrow, it would likely be stayed by court challenges for years. As it stands today, a person carrying a firearm must be intimately familiar with the laws of the specific state they are in. What is perfectly legal in Arizona could land you in jail in California. Ignorance of the law is not a defense. Second, the legal responsibilities of gun owners are immense and constant. Regardless of permit requirements, the foundational rule of firearm ownership is safe handling and storage. In states with constitutional carry, the responsibility is even greater because the state has removed the training requirement that was often a part of the permit process. Many advocates strongly suggest that even if not required by law, seeking professional firearms training is a critical component of responsible gun ownership. Training covers not only marksmanship but, more importantly, the legal use of force, conflict avoidance, and the grave moral and legal consequences of using a firearm in self-defense. A common misunderstanding in this debate is the conflation of the right to carry with the absence of all regulation. Constitutional carry does not mean carry anywhere, anytime, by anyone. The federal prohibitions remain firmly in place. Carrying a firearm while intoxicated, for instance, is illegal in virtually every jurisdiction. Carrying in a place that serves alcohol may be restricted. Carrying in a posted private business is trespassing. The myth of a lawless Wild West emerging from these laws is not supported by the data or the practical experience of the 29 states that have already adopted them. In fact, studies have often shown that violent crime rates in constitutional carry states are not demonstrably different from national trends. And in some of the safest states in the nation, like Maine, New Hampshire, and Vermont, constitutional carry has been the law for a very long time. This is not to say that the laws have no effect, but it is to ground the debate in evidence rather than speculation. Criminologists often point out that violent crime is driven by a complex set of socioeconomic factors far more than by the carry laws for law-abiding citizens. The introduction of the National Constitutional Carry Act also forces a conversation about the nature of rights in a constitutional republic. Is a right something that the government grants you permission to exercise after you have passed a test and paid a fee? Or is it something inherent that you possess unless the government has a very specific, historically grounded reason to restrict it? The bill's proponents, citing Heller and Bruen, argue that the Second Amendment is of the latter variety. They view permitting schemes as an infringement on a pre-existing right, not a necessary prerequisite to its exercise. The dissenting opinions in those Supreme Court cases, however, argue that reasonable, long-standing regulations, including permitting requirements, are precisely the type of historical traditions that the Second Amendment allows. They contend that public safety necessitates a system of accountability and training that permits provide. Looking at the real-world implications, if the National Constitutional Carry Act were to become law enforcement officers across the country would face a new paradigm. In states with restrictive carry laws, the mere presence of a firearm was often probable cause for further investigation. Under a national constitutional carry regime, the presence of a firearm alone would not be grounds for a stop or detention. This shifts the focus of encounters to other behaviors and indicators of criminal activity. It also places a premium on the ability of law enforcement to quickly determine if an individual is a prohibited person, as the act of carrying would no longer be a distinguishing factor. For the average citizen, the change would be most noticeable when traveling. The anxiety and research required to navigate the country's various reciprocity maps would, at least for the act of carrying, become a thing of the past. A citizen legally carrying in their home state would be legally carrying in every state, simplifying travel and eliminating the risk of inadvertently becoming a felon by crossing an invisible state line. The fiscal impact on states would also be substantial. States that currently run permitting systems derive revenue from application and renewal fees. The removal of the mandatory permit system would eliminate that revenue stream. However, it would also likely reduce the administrative burden on state police or licensing agencies that process these applications. The cost-benefit analysis for each state would differ based on how they fund and operate their current systems. Furthermore, the bill could potentially spark a new wave of litigation from states and localities, arguing that the federal government has overstepped its bounds, setting up a major Supreme Court showdown over the limits of federal power and the scope of the Second Amendment. The outcome of such a challenge would have ramifications far beyond firearms, potentially reshaping the understanding of federal preemption and unenumerated rights. In my professional opinion, as someone who studies the intersection of constitutional law and public policy, the National Constitutional Carry Act represents a bold and direct legislative response to the judicial philosophy articulated in Bruen. It seeks to codify a maximalist interpretation of that decision, effectively asking the question, if the right to carry is fundamental and rooted in history, why should any American have to ask a state's permission to exercise it? The bill's reliance on Supreme Court precedent is not just rhetorical. It is an attempt to build a statute that is defensible against the very constitutional challenges it would inevitably face. Whether it would survive those challenges is a question for future courts, but its introduction signals a clear intent by its sponsors to push the boundaries of the post-Bruen legal landscape. Conversely, from a policy analyst perspective, the bill raises legitimate concerns about uniformity and local control. Public safety is often managed most effectively at the local level, where officials have a nuanced understanding of their community's specific needs. A one-size-fits-all national mandate removes that flexibility. It also raises the question of federal overreach. While the Constitution is the supreme law of the land, the enforcement of its provisions has typically allowed for some state variation, as long as the core right is not infringed. The National Constitutional Carry Act would essentially dictate to states that they have no room for variation at all on this specific point, which is a significant departure from the historical norm. For citizens trying to navigate this complex issue, the most important takeaway is the need for continuous education. Whether you support or oppose this legislation, understanding its provisions, its legal basis, and its potential consequences is essential. The debate over the Second Amendment is not going away, and it is a debate that will continue to be shaped by court decisions, legislative action, and public discourse. It is a debate about the very nature of our federal system and the balance between individual liberty and collective security. The National Constitutional Carry Act is just one chapter in this ongoing story, but it is a chapter that forces us to confront these fundamental questions directly. As you follow this issue, pay close attention not just to the political rhetoric, but to the legal arguments, the historical evidence, and the practical realities of how such laws function in the states that have already adopted them. That is the foundation of an informed and engaged citizenry.